Good morning and welcome to the COBRA webinar, where we're going to unpack business rescue in a nutshell. We've got an exciting program this morning. We've got our panelists, Ian Fleming and Peter Gordon from the Engaged Business Turnaround Group. The IQ Business have joined us, Artisha and Emma, and Tasneem from Schindler's Attorneys is also with us, as well as Dean Wright. Welcome to the show. It's going to be a very exciting show with lots to talk about. Ian, do you want to, or should we kick off with Peter? Peter, do you want to just want to unpack business rescue in a nutshell for us? Good morning, Peter.
Morning, Gary. Thanks for that, and good morning to everybody on the webinar. High level business rescue, it falls under Chapter 6 of the Companies Act, promulgated in 2011 in the 2008 Companies Act. Essentially, and the most important thing of business rescue, it provides a steel jacket, as we refer to it, around the company and protects it from any legal action whatsoever. So that's not only people trying to collect money out of a company, it's any legal action. Cannot take place unless authorized by the business rescue practitioner, would have to be appointed, or somebody goes to court to have the business rescue set aside. Other than that, the company is protected. The process is pretty straightforward. There are two ways of doing it: either an affected person, defined as anybody who has direct connection with the company by way of a liability, so shareholders, staff, suppliers are affected parties, and any affected party can go to court to have a court application for the company to be placed in business rescue. Obviously, because it's via court and it's a third party doing the application, it takes a bit longer than the other route, which is a simple resolution of directors. If the board believes that the company is financially distressed, that's defined in the Act as the company is likely to be unable to pay its debts as they fall due within the next 6 months. In general terms, the Companies Act normally extends that to 12 months, but in business rescue, it's 6 months, so a shorter period. Or in that period, the directors believe the liabilities of the company fairly valued will exceed the assets of the company fairly valued. Then the directors have to put to a vote, and this is as per the Act, they have to put to a vote to the board about going into business rescue. If 50% plus one of the directors approve going into business rescue, that resolution, together with a sworn affidavit from the directors, important thing in the affidavit, it has to state that the directors firmly believe that given time through the rescue process, the company will be able to settle its creditors and will be able to reach a financially sustainable position. And if that's in existence, that affidavit, together with the resolution, together with the SIPC form, gets filed. Filing is the day on which the email is sent to SIPC, and the company is immediately in rescue. It then is all very much time-driven. Within a number of days, the directors have to appoint a practitioner who has to accept the appointment. He or she must have the right status. These senior, experienced, and junior practitioners, all dependent on the size, essentially the size of the company. And obviously, a large company has to have a senior, etc. A small one can have any of the three. The practitioner is important. Importantly, is appointed rather. Importantly, with the practitioner, please make sure that he is a business person, he or she, because very often you'll find practitioners, and not to knock the accountants, I'm one myself, or the lawyers, there's enough on this webinar, take either a legal view or a principled accounting view. And anybody who's running a business, certainly in the small to medium sector, knows that running a business is about, making a plan. And you need somebody that has business acumen and business savvy. Once the practitioner is appointed, he's in supervisory control of the board. This makes some companies nervous, but essentially the approach certainly that Ian and I take, and we've done a lot of rescues together, is to work in collaboration with the board rather than against the board. There's no point in taking on the people within the company, unless of course there's been fraud. But taking on the directors is daft, because you get tied up in legal issues with the directors, whereas what you're trying to do is rescue the company, and that is always for us the end goal. Rescue can take place in two ways. Either you have to present a plan, and I won't go into what's going to go in the plan. I'm sure Ian will cover that. But in the plan, you state how much you plan to pay the creditors and over what period. There is a potential to do a compromise with creditors, i.e. you're paying them less than they owed, and all the creditors must agree to that. And if the plan is approved, then the practitioner implements the plan. The important thing there is you've got to get this out as quickly as possible. There has been negative publicity with some rescues that have dragged on for years, and some of them land up in court, and some practitioners have been wrapped over the knuckles as a result, rightly so, because priority number 2 is to do this as quickly as possible. Obviously, priority number 1 is to get to a best solution for the creditors of the company. The alternative to paying creditors through the rescue process, i.e. handing back a financially solvent company back to the owners, is to do a controlled wind down. And the advantage of this over liquidation is we're not selling assets under forced sale. So obviously in a forced sale or a fire sale, prices are going to be rock bottom and the creditors lose out as a result. So it's a low bar to exceed. And so we do this. We do a proper marketing of assets, proper negotiation of assets to sell them at the best possible price under the circumstances. Gary, I think that's it from a high level. Yeah. I mean, there's a lot of other issues. I won't go through them now.
Thanks a lot, Peter. Ian, obviously, COBRA is a pro bono initiative, bringing three major entities together: Schindler's Attorneys, Engaged Business Turnaround, and IQ Business, to offer assistance to distressed companies on a pro bono basis. Of course, we're not going to charge for it. Ian, if you could just explain to the attendees what exactly COBRA will do if they come into the ecosystem.
So thank you very much, Gary, and welcome to the audience. The moment a company comes into the COBRA ecosystem, we will engage with the directors of the company, the management of the company, and we'll under the COVID-19 scenario, we'll typically set up a Zoom conference call or a Teams conference call, or we'll come to your offices, or you can come to our offices. We'll engage face to face, and we'll ask you lots of questions about how you believe the company got into financial distress in the first place, what plans you already have in place in order to get it out of distress, and basically to get a background on the company. What we then do is we start formulating, and as Peter said, you know, him and I have done a lot of work together, and we've got a substantial team now. You know, the Engaged team, the existing Engaged team, plus the IQ Business people who are working with us, plus the Schindler's people who are working with us, and we'll sit down with you and we'll immediately start working out what the best way forward is for your company. Now, and it's very important to get it right from the start, because there's a number of different legal frameworks that we can, you know, sort of work under, and it's very important. There's so many criteria that we need to weigh up in order to get it right from the beginning. The first option is when it's a case of minor distress. The first option that we would look at is business as usual. Company carries on trading the way it was always normally trading, with minor interventions from our side. We have a very strong operational team that can assist, that can get stuck into your business and to plug any holes from an operational perspective, you know, that might exist. And you know, obviously we have the legal skills and the financial skills, and it's a huge skill set that's required to do business rescue and turnaround properly. And that's the reason why your top turnaround teams in the country are not individuals, but actually teams, you know, a number of senior individuals working together. And then we look at the possibility of an informal turnaround. Informal turnaround works quite nice, and we call it informal because it doesn't have the legal protection of business rescue. So because we enjoy a good relationship with the banks, you'll sometimes find an instance where a company is in financial distress and they're paying all their creditors, you know, in the normal course of business. However, the bank, they're in default with the bank. In other words, they've gone way over their overdraft limits, and the bank is getting really nervous. What we can then do is sit down with the bank and say to them, listen, we don't want to put this company into business rescue, but we're going to sit down and we're going to treat it as if it's a business rescue. The board is happy to give us control, and let's work this thing out without the label of business rescue, and you know, sort of without the legal protection of business rescue. knowing that the bank is not going to come and start attaching assets and or liquidating the company. Then there's the possibility of a Section 155 compromise. Now, Section 155 compromise is also legislated under Chapter 6 of the Act. And what the Section 155 compromise does is it allows us to reach a compromise with each class of creditors. Once again, it doesn't enjoy the legal protection of business rescue. So a 155 compromise is something that you'd also do when you're dealing with creditors who are not necessarily aggressive, who are not ready to pull the plug on the company, but are willing to negotiate. And that involves sitting down with each class of creditors and presenting them with a plan whereby each class of creditors is compromised to a certain extent. In other words, you'll say secured creditors are going to take a 10% haircut. We call it a haircut. The proper word is a compromise. Your preferred creditors, your SARS and employees, are going to take, say, a 30% haircut, and your concurrent creditors are going to take a 50% haircut, just as an example. And then once they approve the plan, then it gets made an order of court, and then it gets implemented. And often we'll be involved in the implementation going forward once it has been made an order of court, in order to make sure that it's rolled out properly and all the proper necessary turnaround interventions are in place. Then, of course, we have business rescue as an option, which Peter has just described. I think Gary pointed out earlier that business rescue is certainly not the intention of COBRA, and I think that's what I'm trying to say.
Yeah, I think if I could come in there, obviously the COBRA project is more about rescuing a company than necessarily putting you into business rescue. So those that are in financial distress, we look to bring you out of that, not necessarily to go on to the full-on business rescue process. Is that correct? Yeah.
Absolutely, absolutely, and that's why I'm sort of laying out all the possibilities, of which business rescue is just one. And it really the company needs to satisfy the requirements of business rescue in order for us to put it into business rescue. We try to keep it out of business rescue as long as possible, and business rescue is only used when it is really, really necessary. And then the last option that we always need to consider is liquidation. There's no incentive for us to put a company into liquidation. But in extreme cases where we have, where we've come across companies where there is no reasonable prospect for rescuing the company, then we need to consider liquidation. And obviously, when there's been large-scale fraud and void and sort of dispositions of assets and so on, then a liquidator's powers are greater than a business rescue practitioner's to be able to investigate those frauds and reverse those dispositions of assets. But those are in very extreme cases where there's been definite sort of malicious intent from the directors. But those cases are few and far between, and we haven't come across any of them in COBRA as yet.
Peter, would the business rescue practitioner have the duty to actually say to the company, there's no chance of rescuing you? You're not a good candidate for the project, and you should exit the project, actually.
Gary, look, the two ways, obviously prior to going into rescue, if we decide that really, and a classic of this would be a property owning company, the bank is secured, they can't repay the bank wants to exercise their security, the remaining creditors are not going to get anything, and then really is sensible for the owner, or probably sensible for the owner to place the company into voluntary liquidation. But once it's in rescue, and it's a good question, because what the practitioner, I talked earlier about how the directors have to decide on the reasonable prospect test of saving the company, the practitioner has to do exactly the same. So the practitioner has to state that the first meeting of creditors, which is held 10 days after his appointment, that he believes that there is a reasonable prospect of rescuing it. And then in every communication broadly with creditors going forward, he has to make the same declaration. So in other words, you've got to check it regularly whether your original premise still stands. Just remind us all, this is business as usual. So things never go as fully planned. So things sometimes do go a bit pear-shaped, and it may get to a position where you get to realization you thought you had assets of value and you don't. If that is the case, then the practitioner is obligated to put it into liquidation, doesn't have to confer with the directors or the shareholders before doing so. It is an obligation. Now, once again, as Ian said, and I said earlier, we work with rather than against. So what we would do in a situation like that is probably 99% of the cases, we'd call a meeting of creditors and ask them to agree that this business should go into liquidation, because, and present the reason therefore up front, so that it is a consensus amongst the creditors. But in terms of the act, the practitioner is obligated to put it into liquidation if there's no reasonable prospect of rescuing it.
Okay, Ian, I mean, if the people watching would like to know if they're a possible candidate to enter the program, can all entities in terms of the law enter business rescue, or the business rescue turnaround, or at least business turnaround project?
Yes, absolutely. Anybody is a candidate for business turnaround, Gary. The candidate for business rescue, the requirements for business rescue is that the company has to be in financial distress, and there has to be a reasonable prospect of rescuing the company, returning it to a solvent going concern. The qualification for financial distress is that the company must either be technically insolvent, in other words, its liabilities exceed its assets, or it must be unlikely that within the next 6 months, the company will be able to meet its payment obligations in the normal course of business. And if those criteria are met, then the company is a candidate for business rescue. However, a lot of the people we know in our networks and so on, and a lot of our friends have been approaching us and saying to us, are we okay? Are we in trouble? And then I ask them certain questions. I say to them, what does your sales pipeline look like? What is your ability? What is your debt at the moment? What is your ability to raise debt against assets, etc.? And they tell me, and they tell us, and then we give them. We often say to them, "You're okay. You should be fine. You should be able to get through, through the effect of COVID, or you might not be okay. Come sit with us. Let's work out how we're going to move forward." So absolutely anybody who's concerned, worried in any respect whatsoever should approach us. And remember, as you said, Gary, the COBRA is a pro bono initiative. So all these consultations, these initial consultations, etc., are pro bono. We're literally there to help you and to advise you as to the best way forward.
Great.
Gary,
Thanks,
Gary, just to add to what Ian said there, obviously one important factor is business rescue is for companies. It's directed by the Companies Act, so it applies to companies and, importantly, close corporations. Anything outside of that, a partnership, a sole trader, a trust, a housing association scheme trust, none of those can go into business rescue. So those are prime targets for COBRA, because they can still apply. We're not restrictive in COBRA only to companies; it's to any business.
Yeah. Okay, Peter. Let's look at labour aspects, because there might be some employees in the audience. Let's discuss post-commencement finance for us and the aspects around labour with regard to business rescue.
Look, one of the intriguing things that we often find is when we explain to directors of businesses that their labour are creditors. Employees are creditors each day they've worked for you and not been paid, notwithstanding they've probably got accumulated leave pay, etc. So they are, as I defined earlier, affected people in the rescue. So as an affected person, you have certain rights. You have to be included in all votes, any court action you have to be included in, etc. However, I also said earlier that there's the steel blanket around the company vis-a-vis any litigation against the company, the moratorium as we refer to it. Now that moratorium doesn't, the impact that moratorium has on contracts is you can, and it is an important point, that any rescue practitioner soon after being appointed should suspend all contracts. What does that mean? It means if you've got a lease and you suspend it, a few things happen. You can't be evicted. If you don't suspend it and fail to pay, you can still be evicted from the premises. So at least you've suspended it. And then the suspension itself is the basis for negotiation. So there are ways of dealing with contracts. However, the one contract that is sacrosanct in business rescue is the contract of employment. So in terms of, and it's specifically in Chapter 6 of the Act, is that the employees' contracts must continue. What does that mean? It means that any process that you're going through on a reduction in staff numbers still has to go through the 189, Section 189 of the Labour Relations Act process. So consultation, alternatives, etc., with the one proviso that the reason to be given up front as to why you're going through this process can be fast-tracked, because obviously in rescue, so it's pretty obvious that you can't pay the employees. So employees have to be treated in a separate category, if you like, as employees rather than as creditors, because they wear two hats. They're an employee and a creditor. We know of the recent case brought by the NUM against the practitioners in the rescue of SAA, that the practitioners were shackled, if I might say that, until the plan is published, or the draft plan is published, and that any 189 process couldn't commence until the plan had been published. So the courts do err on the side of Labour generally. That case is being appealed, so the decision might be changed. But generally, employees through that whole process. Now, what we find, and this is not only in rescue, we find it in COBRA as well, and in informal turnarounds, under the current situation. Obviously, it's a unique situation, goes without saying. But employees are fairly open to negotiation. So there's a lot of small companies to medium companies, and large, in fact, who have agreed reductions in payroll for this period. One, right at the beginning of the lockdown, a client contacted me and said what they were doing is they'd said that staff were going to be forced to take their leave pay during this period. Well, that's not a clever thing to do, because you still got to pay them 100% for the period that they were in lockdown. So rather have a reduction in staff costs, because cash really is king at the moment, and you must hang on to your cash as long as you can. And if it means coming to a negotiated settlement with your labour force to pay them less over this period, then that makes sense. But they are well protected.
You did refer to the SAA rescue, and with regard to post-commencement finance, I mean, is this a case where Minister Gordon did not make available the finance? He wasn't prepared to do it, that there was an issue around that aspect?
Gary, look, I mean, the day that, I mean, it's a funny story, but the day that Les Mattison and his cohort were appointed as practitioners, one of my colleagues sent me a WhatsApp and said, you know, how's Les Mattison? Because we know Les, and he's a good practitioner. He meant to say, it is Les Mattison, but it came through as how. And I replied and I said, he's in a bad spot, because unfortunately, whilst the Companies Act is absolutely clear, the practitioner is in absolute control of the company. He can't fire a director. He can set the board aside, or he can pick and choose which directors he wants to use in helping him with the plan, implementing the plan. So he is really in absolute control of the business. And that's not the case with SAA because of the political situation. So that makes it's just a different angle to SAA that makes it almost untenable. I think the day that Minister Gordon decided that $6 billion rand wasn't going to be made available was the death knell for SAA. I mean, and without post-commencement finance, and it is an important question in any rescue, how are you going to fund not only, you know, the payment of my fees, but how are you going to fund paying the staff and dealing with the bank, because the banks very often freeze your account. So importantly, we stay very close to the banks. They've all got separate turnaround and recovery units, and they're all now pretty au fait. It wasn't the case in the early days, but they're all now au fait with business rescue. So we have a good working relationship with them, and you get them to agree to open up the bank account and allow you to continue to trade, the critical part of it. But then also, where's money going to come from? First port of call is obviously always the shareholders. But if there's no funding there, then, you know, we go into the market. Now, it's not a very established market, the distressed debt market, to get people to fund. But importantly, one of the things that we have at our disposal, firstly, any PCF, as we call it, post-commencement finance that comes into the company is immediately preferred. So the practitioner has to pay the PCF suppliers first before they pay the creditors that were on the books as at the date of rescue. Remember, they're frozen and can only be paid out in terms of the plan. In addition to that, the practitioner has access to any unencumbered assets of the company. So, if there's a property or machinery or whatever that can be secured, he can offer that up as security against additional funding into the company, and that becomes super preferent. If the company goes into liquidation, then that creditor, has to be paid first out of whatever security they've got. So, and it had to be that way. Otherwise, why would your suppliers continue supplying you on credit, if that's possible, if they weren't guaranteed in some way of getting paid? The other important thing on PCF is, of course, as soon as you freeze your creditors, you don't have to pay them. So it immediately frees up working capital. But often that's not enough, because if the company's headed to rescue, it means that sales probably haven't been the best over the last few months. So income coming in to pay off the rescue or to settle creditors who have probably already got the company on some sort of hold is not always the best way to fund the rescue. But it is a positive of business rescue, in so much as you don't have to pay those that you owed money to prior to the date of rescue. The other thing that we always say to people, if you're considering rescue and you're the shareholder of an owner-managed business, do not put money into the company to pay the staff or anybody else for that matter, because if it were to then go into rescue or into liquidation, worse still, you just become a concurrent creditor. Rather put it into rescue and then put your funds into the company so that you are preferred as a shareholder loan.
Great, thanks, Peter. As we can see and we can hear that Peter and Ian are absolute experts on this, and I'd love to hear from you. So please pose your questions to Ian and Peter around any issues of business rescue and business turnaround, and get into the COBRA ecosystem, which of course is a pro bono project between Schindler's attorneys, engaged business turnaround, and IQ Business. Ian, I'm going to turn to you again. Can you just tell us? Obviously, everyone's got to be on board. If any party goes rogue, a rescue or a turnaround's not going to work. Tell us about that.
Yes, Gary. Peter and I have both been involved in rescues where the directors or somebody has gone rogue, and obviously that's not ideal. As Peter was explaining earlier, we aim to work with the directors, at all times. But the way we tend to, where there's doubts around the directors and their integrity and so on, the way we tend to work is that we give them the opportunity right from the beginning to work with us, even though we are technically in charge of the board. We give them the opportunity to work with us and to work properly towards towards saving this company. If the directors have bad habits from the past, sort of misrepresenting true state of affairs to creditors and telling stories and that sort of thing, then we try to give them an opportunity to wipe the slate clean and to work with us and to work properly on an open, transparent basis to rescue this company. And obviously, but we have to be pragmatic and realistic at the same time, because it's very difficult to change people. It's very difficult to change old habits. So unfortunately, then we often find that the bad habits start coming back from the directors, and we keep having to override them and that sort of thing. And it's not an to the viewers that you have control as the practitioner, not the directors, because many times directors will like to interfere. I think you need to make it clear to the directors and the shareholders, anyone watching us, that the practitioner can control the process. Yeah, they're absolutely right. And but as Peter said earlier, it's very important to find the right practitioner. It's so important to have the right balance, because a lot of practitioners, sadly, who are working out there are not qualified adequately in terms of skills to be working as practitioners, and that's why business rescue has got quite a bad name since it was started in 2011. So it's so important to find the right business rescue practitioner. So you have to have, ideally, you have the right business rescue practitioner with the right set of ethics and the right set of skills, working with the directors who have the right set of ethics and the right set of skills, and that makes for an easy. There are no easy business rescues, but that makes for an easier situation than we often find ourselves in. Everybody must realize that we work in a very imperfect environment, and it's really about trying to manage those imperfections to the best of our ability. So we try to work with directors who have done bad things in the past. But the moment that they do bad things under our direction, then we need to start, we either need to work them out of the system or we need to override them all the time. And if it's getting to such a bad stage that we know that the relationship is breaking down between the business rescue practitioner and the directors, then, sometimes we've got no choice but to have them removed entirely, or to, and if we remove them entirely and they can still exert influence in one way or the other over the labor force, for example, then sometimes we need to just realize that it's a liquidation. So, but we try our very best to get the directors to work with us as much as possible, because we will never know, us coming in fresh into business, we'll never know as much about a business as the directors do about their specific company. It's a company they've built up over the last 10 or 20 years. They've got extensive relationships with suppliers, with customers, with the public at large, in relationships which we could never replace, And, a lot of, you'll hear stories of business rescue practitioners who have come in, to a company and kicked the CEO out of his seat and sent him home, and then they think they can run the company. It just can't work like that. It just really can't.
Yeah. I'm going to come back to you now, Ian, but obviously once this process begins, you meet, it's 10 days, am I correct? 10 days you meet with all the parties to get the process going. Take us through that.
No problem. So the moment a company goes into business rescue, the company, so remember the directors put the company into business rescue. The business rescue practitioner is not involved yet at that stage. He's then got 5 business days, in other words, 1 week normally, in which to appoint a business rescue practitioner, and to advise all the creditors of the fact the company is in business rescue. Once he's appointed the practitioner, then the practitioner is in control. And then the practitioner has 10 working days, or 2 weeks in normal circumstances, in which to hold the first creditors meeting and the first meeting of employees. And the purpose of that meeting is to explain to the creditors and to the employees, which are technically 2 separate meetings, that he believes that there is a reasonable prospect of rescuing that company, or to give his opinion as to whether there's a reasonable prospect of rescuing the company. Inevitably, he will state that there is a reasonable prospect, because there normally is a reasonable prospect at that stage of the game. Remember, he's only had 10 days in which to investigate the affairs of the business, which is a very short amount of time. If for any reason he believes that this company is a no-hoper, there's no reasonable prospect, then as Peter explained, he has the duty to place the company into liquidation at any stage of the business rescue process.
Yeah, I mean, take us through the timelines. Then you would, all in all, you want this process to be expedited. And if I'm not mistaken, it's 35 days. Take us through the timelines. You spoke about 10 days, and take us up to that 35-day period that you've got. Certainly.
So yes, timelines are very critical, because remember, everything is urgent in business rescue. You've essentially got a company to rescue. Liquidation processes tend to take a long time, because you're just winding up a company. It's not a simple thing, but you're winding up the company and you are disposing of the assets under liquidation. In business rescue, you are literally trying to rescue and turn around the company. Therefore, everything is urgent. Often, court matters in business rescue are often urgent applications, because everything is urgent. You've got companies to save, you've got creditors to look after, you've got employees to look after, you've got shareholders to look after. So everything is urgent, and hence the very tight time frames in business rescue. So I've explained the time frame as to the 10 days to hold the first creditors meeting. Then within 25 business days of the practitioner being appointed, in other words, 5 weeks typically, then the business rescue practitioner has to publish a business rescue plan. And the business rescue plan typically contains, it's everything that a business rescue, it's everything that a business plan would contain. It literally explains what the intention is of the business rescue practitioner as far as turning it around, how he's going to generate new revenue, how he's going to cut costs. A detailed explanation of all these things. It's an analysis of creditors by class of creditors, by independent creditors and by non-independent creditors. It's a breakdown of the assets of the company, what is available for sale, what assets are available for sale now out of non-revenue generating assets versus which assets cannot be sold and are needed to generate income. It's an analysis of what any shareholding changes that are required in order for the business rescue plans to be carried out, things like rights issues that are envisaged in order to raise capital, and so on. And very importantly, there's an analysis of what the company will achieve for creditors in terms of dividend in a liquidation scenario versus what the creditors will get as a dividend under a business rescue scenario. And that's a very important part of it, because at all times we need to consider, is the company going to do better under business rescue as opposed to the alternative, which is liquidation? And it's very important for us to show that the company in the business rescue plan, the company is going to get a better return for creditors than in liquidation. And it has to be a substantially better return. There's no point in us showing 15 cents dividend for creditors in liquidation and showing an 18 cents return for creditors in business rescue. Then you might as well liquidate the company. So yeah, that's very important. And then yes, 3-year financial projections are another critical element of the business rescue plan. And remember, the business rescue practitioner has a very short amount of time in which to put together the plan and the projections. And we all know that Peter often says the day after a cash flow projection is put together or presented, then it immediately becomes, it's wrong the next day. And that very often is the case because, so many unpredictable things happen. Things like COVID-19, for example. How was anybody supposed to predict that was going to happen when they did a business rescue plan and forecasts a year ago? It was impossible to predict it. So, and there's so many influences, both external and internal, that can upset the business rescue plan, that can turn it on its head, that can render the forecasts incorrect. So the forecasts that are prepared in the business rescue plan are literally the best estimate of the way that the company is going to play itself out financially for the next 3 years, the best estimate that the practitioner can make at that very moment when the plan is presented. And it obviously needs to be in good faith as well. And that forms part of the plan. Back to timelines. Very often, business rescue practitioners, especially in complicated business rescues, will ask for an extension of time in which to publish the business rescue plan. It's not uncommon at all. However, if there's a paradigm shift, like in the outlook, such as in the case of SAA, the practitioners were probably more or less ready to publish the plan at the end of March. But COVID-19 and the lockdown hits, and the airline industries across the world basically shut down, and there was no way. It was such a complete change in direction, such a paradigm shift, that the practitioners had no choice but to extend the publication date for the plan. So if something like that happens, the right thing to do is to extend the publication date of the plan. However, the practitioners are obliged to get the plan out as quickly as possible in order for the business rescue to carry on. 10 business days after the plan is published, then the practitioners hold the second meeting of creditors, where the creditors get together with the practitioner. The practitioner presents the salient points of the plan, and then the creditors have an opportunity to vote on the business rescue plan. The vote that is required in order for the plan to be approved and then adopted is a 50% vote of independent creditors and 75% vote of non-independent creditors. That non-independent creditors includes shareholders and directors and so on. Just to point out, I'm sure Peter would correct me if I didn't point this out, but the vote is required, 75% and the 50% votes are required by the credit or by value. In other words, the value of your creditor's claim is the most important thing, and it's by the people who choose to vote, by the creditors who choose to vote, be it in person or via proxy.
Great. Thank you very much for that, Ian. That was comprehensive. Peter, let's talk a little bit about reckless trading on the part of directors. You want to take over from there?
Very yes, thanks. And it follows on from what Ian was saying about the collaborative approach we have with directors, but it's certainly such a common question that is asked of us in the early stages prior to making the final decision to go into rescue or not by directors. It's on a number of levels. Directors are always anxious about reckless trading. Now, if you're financially distressed and you're having a discussion with us and you're considering business rescue, by default, you're financially distressed. I think we've said on these webinars in the past that there's probably not many small to medium companies at the moment that are not financially distressed. So, but normally it's a more difficult decision to take. If the directors approach us, the thing that we point out, well, first of all, reckless trading, that's Section 22 of the Companies Act. If a director, under the fiduciary duties that are imposed on them by the Companies act in a reckless manner, i.e. you're getting credit granted to the company, so you're taking money from people or goods from people, knowing that you're going to be unable to pay it, that is a very broad definition of what reckless trading is about. And if you fall into that category, then a aggrieved creditor can go to court to claim that the director was trading recklessly and therefore importantly, personally liable. So directors obviously understandably are quite anxious about that. Now, there was a moratorium given on reckless trading by the DTI at the beginning of lockdown. I think it's still in place. Which basically said that these provisions of Section 22 of the Companies Act would not apply during lockdown. And that's obviously relieves some of the pressure, but still it is a question that directors would have. The other important thing with directors is if the practitioner, and Ian's covered a couple of the things on the difference between liquidation and business rescue. One of the important differences is the practitioner is obligated to examine the affairs of the company. If he or she finds anything that is untoward, i.e. contrary to the act or any regulation, then they're obligated to report that to the authorities. The act is not clear on who the authorities are, but it often is driven by whatever the issue is. Report it to the authorities, instruct management to cease doing whatever they're doing, and make sure that the practice is stopped. And that's the end of their obligation. A liquidator, on the other hand, has full summonsing rights. So a liquidator can call for a 417 inquiry. It's like a mini trial, and he calls for investigation, normally chaired by a retired judge, and the commissioner of the inquiry will ask questions of the directors as to ascertain whether there has been any, firstly, reckless trading, and then importantly, two other provisions is transactions called voidable transactions and undue preference. A voidable transaction is one that took place and should not have taken place, and that's a classic of, we're going down the tubes, let's sell the property to the shareholders or to the director's wife at a discounted value. That would be a voidable transaction because it's been detrimental to the creditors. The other is undue preference. So I've got two creditors, I owe them both 50,000 Rand, and I go and pay one the full 50 and not anything to the other. That would be undue preference, and the one I've paid might be my brother-in-law. So that's going to fall into undue preference. In those instances, the only time that the practitioner does have to point out such transactions, but the only time that those have any teeth is in liquidation, because in liquidation, a charge can be brought against the individual, and the recovery of that amount of money, whatever was paid, either as voidable or undue preference, must be paid back to the company. One of the important things that directors tend to forget, and it is an intriguing point, directors wear many hats, and it's often pertinent for us to remind them, when a director approaches us, are they approaching as an employee of the company, i.e. they're an executive director and they're on the payroll, so they're an employee, they have rights in terms of the Companies Act? Are they approaching us as a directors, they have rights and most importantly obligations in terms of the Companies Act, then very often they're a shareholder. And a shareholder in a business rescue has very little rights if you don't affect their basic rights. So if they're ordinary shareholders and you don't go and affect the terms and conditions of their shareholding, then Ian took us through the voting process. They don't have a vote in the plan, merely being a shareholder. Obviously, often shareholders are shareholders and lenders to the company, then they're creditors and you treat them as such. So it is important. The other thing that Ian pointed out is, and I think you both used the word rogue, when a director goes rogue, it's important to understand what's driving the director. Because you sit with the director and you can see that he's not fully in line with the business. Then you find out, he's been under declaring his tax, for example, or there's a transaction that he did that he knows is possibly illegal, or he tried to do some sort of underhand action before because he knew he was in trouble and he thought that this would manage to save the company, and it didn't, and now he's talking to us. So their attention gets directed. Also importantly, a lot of shareholders particularly have signed personal sureties. Now that's also an important question that we always ask, because a personal surety is not protected by business rescue. So if the bank has taken personal guarantees off the shareholders, the bank has the right to go after those shareholders and not wait for the business rescue plan to see how much of the principal debt's going to be repaid in rescue. They can go fully against the shareholders. Now, whilst we're not there to protect the surety giver, if I can call it that, we do, if those people are important to the business, try and resolve that with the banks or whoever holds the security. Because what you don't want is a director who's constantly worried that he's going to lose his house and family if the bank manages to exercise their surety against him. So it is an important thing, and it just underlines why it's important for us to work with the directors rather than against them.
Peter, if I could just raise the issue around the moratorium. I mean, do you find that directors take advantage of this, and that there is a moratorium that creditors cannot go after the company? Just take us through that one.
Gary, I look at it as the fundamental, most important point of business rescue, and it is most certainly the most, it's on the top of the list of the pros, because obviously there's some cons of going into rescue as well, but it is on the top of the list of the pros. So, the trick here is do not wait too long, because quite often that liquidation decision gets taken away from you and from anybody advising you because you've just waited too long, and it is now really it's on the deathbed and it's not going to be revived. I'm talking about the company here. Whereas if you've got a situation where directors are concerned, but they haven't had any shot across their bow. No, they may have failed to pay the taxman, the VAT and the PAYs in arrears. Some of the creditors have slipped into the 60 or 90-day level. The one sign to watch out for is the point at which a director gets what we call a Section 345 letter. That's the application or the threat of application to court to have the business wound up. Now, what you don't want is to have an application in court already settled before you decide to go into rescue, because importantly, you cannot elect to go into director's voluntary rescue if there are outstanding liquidation applications against the company. We will, in that case, go and negotiate with the holder of that right to try and negotiate with the applicant to have his liquidation withdrawn, and that normally means you're having to pay the applicant fully. So it is not clever to wait for that time. As I said earlier, it's a very quick process to put the company into business rescue through the resolution process. And in that case, make sure that you do it before any applications lodged at the courts. But yeah, it is an important thing to just watch out for.
Just a reminder that you're on COBRA, and this is a pro bono initiative between Schindler's Attorneys, Engage Business Turnaround, and IQ Business. Please post any questions you have to Ian and Peter. They have a wealth of knowledge. And if you wish to enter the COBRA ecosystem, please contact us, cobra.org.za. www.cobra.org.za is our website. You can find our information there, and our practitioners will assist you with turnaround. Ian, I don't know if you were at liberty to assist us with practical advice with regard to variable costs and cost models and structures with regard to a company going forward.
Certainly, Gary. And, right from the beginning, when, the lockdown was looming, we've been advising companies that there's going to be a complete change in the way that the country does business, and the world for that matter. And it is so critical for companies to move to what we call a variable cost model, whereby the costs that were previously considered to be fixed, such as rental and staff, for example, are now made into variable costs. And Spur Group came out over a month ago and said once the lockdown is lifted and they can start operating again, if they do start operating, then they will only be able to pay their landlords a very small turnover-based rental from the beginning. And that's exactly what we've been prescribing to companies. We've been sitting down with landlords on behalf of companies, negotiating with the landlords, saying to them, the company can only pay a very small turnover-based rental to start off with. And the landlords have been very reasonable up till now. Presumably, and most likely, there is not a queue of tenants lining up to come and take the place of the tenants that we've been working with. So that makes the landlords a lot more negotiable. And the same with staff. We've been saying we've commenced the Section 189 process under business rescue, and as part of the process, we need to consult with the staff as to what the options are available as opposed to the retrenchments. And one of the options we've been putting forward very strongly is taking a vastly reduced salary, often supported by the TERS allowances and so on, but a vastly reduced salary, which should the company start trading, get up to normal trading again, whether that takes a year or two or even 2 years or more, then at least at the end of the day, the employees have still got a job. At least they're still able to put some food on the table in the interim. So there's various ways in which a variable cost model can be introduced. But what we've been doing is sitting down with these companies and working out, analyzing their cost structures very intensively, and wherever possible, changing fixed costs into variable costs, whereby the variable costs are linked directly to the turnover of the company or to the gross profit of the company in some cases.
Yeah, sure. I mean, I see we have about 7 minutes left. Please pose all your questions if you have them. Ian and Peter would be available to ask these questions. Ian, if I could just ask you with regard to insurance, and particularly the restaurant industry, with regard to what kind of insurance the restaurants have taken out, and the difficulties around what they're having with the insurance companies, who often are raising the fact that it's not about the COVID-19 virus, but the fact that the South African government has actually brought about the lockdown. That is, in fact, the issue, and so therefore they're repudiating claims. Are you finding that in the COBRA ecosystem?
Yes, we're finding a lot of business interruption policies which are being repudiated. And the insurance companies and their attorneys have obviously sat down and analyzed these contracts very carefully. And as you stated, one of the big ones is they're blaming lockdown as opposed to COVID-19. A lot of business interruption policies specifically specify that they'll only pay out in the case of physical damage to property. So that's another problem. Obviously that makes it very difficult to argue. But we've come across policies where the insurer is trying to repudiate it, where it specifically does state that business interruption if in the event of business interruption taking place as a result of a disease or something similar, then the company will pay out. And those insurance companies are in a little bit of a treacherous position, and the way we're approaching those and the way we've approached 1 or 2 business rescues And where that is the problem is to state in the plan that we are going to litigate against the insurance company in order to achieve some sort of settlement or to get the claim paid out in full. And we've, in the past, Peter and I have had business rescue plans where the entire business rescue plan is essentially centered around an insurance claim and the company litigating against the insurance company in order to get paid out. And it often has been under business interruption policies. So a business rescue plan can be a very simple plan that states we are essentially waiting for an insurance company to pay out and we're negotiating with them, or we are litigating against the insurance company in order to get them paid out. We had a case a few years ago and it was a very simple plan and a very good outcome at the end of the day, where a factory had burned down and the insurance company, the directors were negotiating with the insurance company. There was no litigation involved, but the case had dragged on, the negotiation had dragged on for a long time. And the creditors were starting to get a little bit itchy and threatening legal action against the company, threatening litigation and so on. And we put it into business rescue because of these threats. And literally 3 weeks after we put it into business rescue, the claim was approved, the insurance company paid out, and all the creditors were settled in full. So that was a very nice one. There was no litigation involved at all. But those easy ones come across our desks very seldom. Normally, it's a lot more complicated than that.
Yeah. I don't know if Peter or Ian, you want to answer Tony's question. Tony's got a question. How do you determine the value of the company's assets as it's an internal accounting exercise? Peter, do you want to have a go at that one?
Gary, yeah, look, I mean, these generally accepted valuation methods for companies, globally accepted. So it's a well-developed industry, is company valuations. If the company is a going concern, then is certainly accepted in any court matters, is what we call a discounted cash flow. So the actual individual value of the assets is not that relevant. It's more based on the discount in the value of future cash that an investor could expect to get from the company. It's quite a complicated formula, but a lot of unknown factors that have to be brought into account. But that is certainly the preferred route. In a broadly property companies, one would normally work on what is called the net asset value. But remember, as I said right at the beginning, financial distress is based on assets importantly fairly valued and liabilities fairly valued. What that means is what's in the balance sheet is often not the case. So you've got a property that might be worth a lot more than shown on the balance sheet, or you've got assets that haven't been depreciated as quickly as they should have been and are worth a lot less. Now, the value that a person doing on a net asset value would have placed on those is broadly willing buyer, willing seller. So, there's a motor vehicle on the books. Let's see what the book price is per the Mead and McGraw there, or what's been advertised on the various platforms now that we have access to on the internet, and see what that vehicle could be sold for based on year and usage, etc. So you would go through an individual process of valuing the assets and then establishing the value of the liabilities. People think that that's surely what's on the balance sheet, but not always. Often there are provisions there that aren't going to come to fruition, or often these litigation matters that aren't included in liabilities, and the assessment is the company's about to lose. So you would bring those in as a liability, just for two examples. Once you've got that, then you've got the fair net asset value of the company. So it isn't, and importantly, isn't the balance sheet. The balance sheet's not a good, it is a snapshot at a point in time, but it's not a good assessment of what the value of the business is. Clearly, the other extreme is liquidation. And unfortunately, in liquidation, remember, it's under the auctioneer's hammer and the vultures are circling. So in situations like that, you can expect, certainly on properties, that they're going to go for anything from 20 to 50% below what's considered a fair value. Recovery of debtors, if they're long overdue, you'll bring them down to as low as 10% of their value. So there are various formulas that we use in the industry to assess what the value is, and that's how we get to the final valuation.
Great. I see that it's 11 o'clock now. Ian, Peter, I think we're going to wrap it up there. Thank you very much for joining us. And thanks to the attendees for joining. As always, every day we have webinars. Tomorrow, 10 o'clock, we've got another exciting one. Fleet Elite are joining us to unpack assets. And at 3 o'clock, Sofiso of RQ Business is doing an economic wrap-up for us of the weekend, of the week's economic activity. So please join us then. Remember, COBRA is a pro bono initiative, free advice from Schindler's Attorneys, IQ Business, and Engaged Business Turnaround. So until tomorrow, cheers to everyone. Bye.
Thank you. Cheers.